Good evening, everyone. Welcome to Other Voices Online, an ongoing series of conversations with activists and experts addressing the critical issues of our time. Now going into its 24th year, Other Voices is brought to you by Peninsula Peace and Justice Center. I'm your host, Paul George. Before I get into tonight's program, I want to take just a moment to send out a special thank you to a very special person. For the past decade and a half, even a little bit more than that, Other Voices has been directed by probably the most dedicated volunteer the Peace and Justice Center has ever known, TD Daniel. Whether in the TV studio or online, TD has been essential in helping us put together over 200 episodes of Other Voices, ultimately seen by thousands of activists. Beyond the TV programs, TD has led virtually every video production the Peace and Justice Center has undertaken in all those years, dozens of them, from videos of major speaker events, like when we've hosted Noam Chomsky or Amy Goodman, to large marches and rallies, to small intimate events, all resulting in hundreds of hours of informative and important content. Now, TD has decided it's time to hang up his director's headphones and retire from video production. I don't really have the words to convey the depth of my gratitude other than to say, job well done, thank you, my friend. And with that, I will also extend a warm welcome to the newest member of our team, Stan Eng, who is directing for us tonight. So tonight, we asked the question, why do more than 60 million Americans believe claims that are at best unsubstantiated and at worst demonstrably false? How do we rein in the big lie and other disinformation without damaging free speech protections? Our guest tonight has an idea. Professor David Sloss is an internationally renowned scholar who has published 3 books and dozens of law review articles and book chapters. He is the John A. and Elizabeth H. Sutro Professor of Law at Santa Clara University. He has a decade of experience in the federal government, where he helped draft and negotiate several major international treaties. Alarmed at the role played by disinformation in the 2016 elections, he set to work writing a book about information warfare and social media. His research ultimately led him to draft a proposed federal statute that is designed to reduce the electronic amplification of lies and misinformation while staying within the narrow confines of the Supreme Court's First Amendment doctrine. David Sloss, welcome back to Other Voices.
Thank you. It's a pleasure to be here.
I was just trying to, it's been a couple of years since you were here. It was, we were in the TV studio at the time, and we were just coming up to the first impeachment of Donald Trump. A heck of a lot has happened since then, and you've kind of headed off into a new direction with this, looking at social media and disinformation. I wanted to ask first how you got going there, and I found in some of your online writings a nice quote that I think helps to explain it. So let me start with that and then turn it over to you, why you got interested in this. You wrote, quote, "In my early career, I worked for the federal government on nuclear proliferation and nuclear arms control issues because I feared that nuclear weapons posed a threat to humanity. I wanted to help mitigate that threat. For the past few years, I have devoted much of my time as a scholar to the problem of disinformation. Today, I fear the traditional tools of disinformation, combined with modern technologies for electronic amplification, pose a significant threat to democracy in the United States and elsewhere," end quote. What is it in your research while you're looking into the 2016 election that freaked you out so much? I think we all know why, but I'll let you put it into your words.
Yeah, so as you know, revelations started coming out in 2017 about Russian interference in the US election in 2016. And, I was concerned about that as a citizen, but I didn't dive into sort of researching it right away, in part because there was a lot, I knew basically nothing about social media. And while I had done a lot of work on constitutional law, I was by no means a First Amendment scholar. But then at some point in 2018, I decided it was worth really diving into this stuff and learning more about it. And I drew partly on my background as an arms control negotiator, where I'd spent a lot of time dealing with what was then the Soviet Union. So I felt like I had some relevant background there in sort of Soviet studies and international affairs. And I was, and had been for a while, a sort of an expert on US foreign relations law. But I had to learn a lot about social media, and I had to learn a lot about the First Amendment. And in the process of sort of writing this book, which will be coming out next year, I broadened the focus because I also became very concerned about Chinese information warfare. So the book really focuses on Russian and Chinese information warfare. The book manuscript was essentially done in November 2020, and then January 6th happened. And so after January 6th, I started shifting my focus a little more to domestic disinformation rather than foreign sources. And the domestic sources of disinformation pose an even greater challenge from a First Amendment standpoint in terms of thinking about how you design regulatory responses that will pass muster under the First Amendment.
Yeah, one of the articles, I guess it was a blog post that you sent me a link for, kind of outlines the narrow path you have to walk in trying to craft something like this. I think the title of this blog post kind of says a lot. Riot in the Capitol, blame the Supreme Court. Can you talk about some of these Supreme Court decisions over the past many years that make it so difficult for anybody trying to draft legislation to rein in this volcano of misinformation, disinformation that we're getting on social media just constantly? And I think we all know what the problems are.
So, I'll talk about a couple of decisions, but there's actually one very important sort of non-decision that is worth starting with. So,
okay,
for a period of several decades, the Federal Communications Commission applied something called the Fairness Doctrine. And the Fairness Doctrine came under some criticism, and it was subject to some problems. But what it did, which was good, is it made sure that when radio and television broadcasts talked about the news, they had to preserve at least some degree of objectivity, consistent with traditional principles of journalistic ethics, right? And there was a Supreme Court decision in the 1960s in a case called Red Lion that upheld the Fairness Doctrine. It was actually subject to a challenge under the First Amendment, and the court said, no, this is perfectly valid, it's okay under the First Amendment. But then surprisingly, almost 20 years later in 1987, the Federal Communications Commission itself came out with a decision that effectively said the Fairness Doctrine is unconstitutional, it violates the First Amendment. And we don't need to go into the details of that decision, but it's actually very shocking that after the Supreme Court has said this doctrine is constitutional, you get a decision from the Federal Communications Commission saying, no, it's not constitutional, and therefore we're repudiating the Fairness Doctrine. And the Supreme Court let that stand. They could have stepped in and overruled that, or they could have stepped in and sort of given a different view on that, but they essentially sat on the sidelines and let the Federal Communications Commission overrule the Fairness Doctrine.
And nobody went to court to try to change that, or?
It was reviewed by the DC Circuit. The DC Circuit upheld the decision of the Federal Communications Commission, although they didn't base their decision on the First Amendment. They based that decision basically on statutory and administrative law and said, look, if the FCC wants to change how they go about doing this, they can do that. That's within their power under the statute. So they the DC Circuit sort of ducked the First Amendment question, but which again was a little bit weird because the FCC had relied on that. And then it was appealed to the Supreme Court, but the Supreme Court didn't take the appeal. They just basically, didn't take it. So.
And I've got to ask, this was 1987, Ronald Reagan was president. Did he have something to do with this?
Yes, Ronald Reagan definitely had something to do with this. So the commissioners on the Federal Communications Commission are appointed by the president. And I don't remember now how long their terms are, but by the time we get to 1987, most of the commissioners had been appointed by Ronald Reagan, because he had been in office for 7 years at that point.
Yeah.
Maybe all of them had been. I'm not entirely sure about that. But this was definitely part of the sort of Reagan Revolution, if you will, abolishing the Fairness Doctrine. So that decision by the FCC, when the courts let it stand, really sort of opened the door for a dramatic change in the media environment. It was shortly after that Rush Limbaugh took off, and then Rush Limbaugh became a sort of a template for others to follow. And you start getting a lot of radio shows and then later TV shows that are basically, you've got people who are political activists sort of trying to maintain a thin veneer of acting as journalists, but they're really being political activists, and that sort of opens the door then for a lot of misinformation. So fast forward now to 2012, there's an important Supreme Court decision from 2012 in a case called US v. Alvarez, where Justice Kennedy wrote the opinion. This was one that he was only writing for 4 justices, not for 5 justices. So it gets a little less weight that way. But in effect, what Justice Kennedy says is that, from a constitutional standpoint, lies get as much protection as truth. And Congress really has very little ability, if any, to, regulate lies, at least in the political context, right? And there's a long tradition of Congress being able to regulate lies in the commercial context, false advertising, right? But
right.
Kennedy views that as very different and thinks that, if we're dealing with political speech, we don't want Congress trying to draw lines between what's true and what's false. And therefore, lies get the same constitutional protection as truthful claims. Now,
wow.
As I said, he's writing for only 4 justices. He got some pushback from different corners. But that is basically accepted as the sort of governing interpretation of the First Amendment right now. And it essentially means that any effort by Congress, at least if you accept Alvarez as good law, right? You could challenge Alvarez and say it was wrongly decided. You might get somewhere with that, it's hard to say. But if you accept Alvarez as good law, then what it means is anything that Congress does to try and draw lines between true and false speech is going to be subject to strict scrutiny, and any law that is subject to strict scrutiny under the First Amendment is likely to be found unconstitutional. So that's sort of one problematic decision. And then the next one that I want to focus on comes along 5 years later, and that's a case called Packingham v. North Carolina, decided in 2017. And again, it's Kennedy writing the opinion. And this is about North Carolina law that essentially said registered sex offenders cannot have social media accounts. And the court was unanimous in saying that law was unconstitutional. And I think they were right in the outcome. But they didn't all agree on the rationale. And in particular, Kennedy had some very expansive rhetoric in there that, effectively says, or at least seems to say that the internet is the sort of new place for the new public forum, the new place for speech, and therefore anything Congress does to try and regulate speech on the internet is highly constitutionally suspect. Alito wrote a separate concurrence in which 2 other justices joined him and pushed back on that and said, hey, you're going too far here. We got to give some leeway for Congress to be able to regulate speech on the internet. But nevertheless, in that opinion, Kennedy's writing for 5 justices, so that's a majority opinion that seems to say that, anything Congress does to regulate speech on the internet is highly suspect from a constitutional standpoint. So you put Packingham together with Alvarez, and it sort of makes it look like, well, anything Congress does to try and discriminate between true and false statements on the internet, the court's going to strike it down.
So am I right that Packingham was actually the first time that the Supreme Court ruled on a specifically internet-oriented case?
No, they had gotten some internet cases back in the 90s. An important one was Reno v. ACLU back in the 90s was an internet case. But Reno, in my mind, is not as troublesome as Packingham because of this expansive rhetoric that Kennedy uses in Packingham.
So it sounds like you've got a very narrow path to walk here. And I take it the legislation you're proposing does not come close to Congress trying to regulate speech per se on the internet. Let's shift over and get focused on what you've drafted here and what you're trying to pitch on Capitol Hill right now.
Okay, so I would highlight sort of 3 key features of my legislative proposal. One is that it focuses not narrowly on social media, but much more broadly on what I'm calling electronic megaphone companies. And the reason for doing that is that there's a very important book that was published a few years ago by a group of scholars at Harvard. The title is Network Propaganda. And in that book, they did some very detailed, sophisticated empirical research to look at how misinformation spreads. And basically what they documented is that social media is a relatively small part of the problem. What you get is an interaction between people on social media, Tucker Carlson on Fox News, Rush Limbaugh on talk radio when he was alive, major influencers out there who are using both television and radio as electronic megaphones, interacting with social media, blogs, and podcasts, and you get a sort of a feedback loop among all these technologies. So one of the things that I propose that is different from other proposals floating around out there in Congress, you got to deal with the whole range of electronic megaphone or electronic amplification technologies, right? That's one thing.
I like that term, electronic megaphone.
Well, I didn't coin that term. Other people have used that term, although I may have coined the term electronic megaphone companies. I'm not sure.
Okay. All right, we'll put that one in your column. Okay, so that's point 1, very broad and not just social media, but taking in all kinds of mass communication. Right.
Point 2 is that if you think, sort of take a step back and think broadly about, if we're going to do something about limiting what I'm calling the electronic amplification of misinformation, you need somebody to decide essentially what's true and what's false. And there are basically 4 options about who gets to decide. One option is the government decides what's true and what's false. And I think everybody across the political spectrum agrees that's a bad idea. That would violate the First Amendment,
Probably so, yes.
So we can sort of take that off the table. Second option is more or less what we've got now, which is we let these large private companies decide what's true and what's false. But there's also a lot of sentiment, again, across the political spectrum on both left and right. That's not working very well, right? Particularly in light of revelations that have come out about Facebook in the last few weeks. There's a lot of people who are pretty dissatisfied with a system that says we essentially leave it to these large private companies to decide what's true and what's false. Right?
Well, especially in light of that recent Facebook whistleblower who told us that they've been lying to their own oversight board. that they've appointed to fulfill this function. They're not even leveling with them.
Yeah, so I think that, like I said, there's a lot of agreement that's not really a very good approach. A third approach, which some people like, is that, well, you leave it to the individual consumers, and we let individual consumers decide for themselves what's true and what's false. But again, here, there's a lot of empirical research that suggests individual consumers aren't actually very good at doing this. And they're particularly not good at doing it when they're being bombarded with a flood of misinformation, right? So that leads to the fourth option, which I think is the best option, which is you farm out this task to sort of independent, non-governmental fact-checking organizations. And that's essentially what my statutory proposal does, is it sets up a system where we're going to let these independent, non-governmental fact-checking organizations basically make determinations about what's true and false. But you could say, well, they're already doing that now. What's different? I'm sort of basically building in a system, and we can talk more about the details later, that is designed to ensure that those determinations actually have a lot more impact than they do right now, right? And that sort of leads to my third point, which is that most of the proposals out there for regulating, and here I'll just talk about social media, focus on sort of bad content rather than bad speakers. And focusing on bad content creates a problem that others have referred to as the sort of whack-a-troll problem, right? Basically, somebody puts out something bad, you take it down. Somebody else puts something bad, you take it down. And that goes on sort of ad infinitum. And the people who are trying to get rid of the bad content basically can't keep up with the people who are putting out the bad content because it's so much of it out there. And here, this is part of what Facebook says in its defense. And there's some validity to this, right? It's, hey, we're trying, but we've got like 3 billion users out there, and it's pretty hard to actually, monitor every post of all 3 billion users to get down all the bad content, right? So my proposal would focus more on bad speakers, and would particularly focus on individuals, and this is a statutory term that I created, persons with large electronic megaphones. And the statute would include numerical thresholds and say, essentially, people who reach an audience above this threshold are the ones we got to focus on, because they're the ones whose voices are reaching millions of people, right? So if we can monitor those people with large electronic megaphones, identify the ones who are repeatedly putting out misinformation, then we can take steps to sort of de-amplify those individuals. And de-amplify could be you just suspend them from the platform temporarily, or it could be sort of technical measures implemented by the companies to sort of reduce the size of their audience, right? But that's the basic idea. And then let me just add one other point and then I'll stop, which is because the First Amendment basically limits the government's ability to do that itself, the statute sets up a scheme that sort of incentivizes private companies to de-amplify those persons with large electronic megaphones who are sort of repeat offenders who are continually putting out misinformation.
Incentivize in what way? You're not proposing fining them for allowing these big megaphone people to keep spewing out of their megaphones, are you? Or
the primary incentive is that you get the statute sets up a system with regular reporting to Congress. So the statute would create this new entity, the National Endowment for Fact-Checking. The National Endowment for Fact-Checking, a big part of its job is to sort of distribute federal funds to these independent fact-checking organizations, but it also serves a very important reporting function where it's reporting to Congress basically on a quarterly basis and saying, here's all of the, these people with large electronic megaphones who received warnings. Here are the companies who are amplifying their voices. We went to all these companies and said, we think you should de-amplify them because they're spreading misinformation. And here are the companies that cooperated with us, and here are the companies that didn't cooperate with us, right? So if you start getting reporting to Congress every 3 months over a period of time, and there's certain companies that are showing up in every report saying they didn't cooperate, they didn't cooperate, they didn't cooperate, you know, partly that's bad publicity for them, and that itself might get them to change their behavior. But if that's not enough, the Federal Communications Commission arguably has authority under existing statutes to do something about that. So the statute, my proposed statute doesn't grant them any additional authority, but it also doesn't take away whatever authority they've got. So down the road, if there's certain repeat offenders in the sense of companies who this new nonprofit group is constantly going to someone saying, we think you should de-amplify this person, we think you should de-amplify this person, and they just consistently say, no, 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 we're going to have a track record on that, and that track record could potentially be a springboard for further action, either by Congress or by the Federal Communications Commission.
So if I'm understanding this, the first level of attack on these people who are spreading such huge lies is, I guess, call it a name and shame them.
Right.
And is there any evidence that that works? Naming and shaming.
I believe there is. Now, this is a contested proposition, but naming and shaming has been the sort of primary mechanism for pressuring governments to comply with human rights obligations for the last 30 or 40 years. And there's an ongoing debate among scholars about how effective it is. But I think there's some good empirical research to suggest that this does work. And it probably works better in democracies than it does in authoritarian countries, right? Authoritarian countries are largely immune to naming and shaming, but in democracies, it actually has more of an impact. Right?
So who are these recognized fact-checking organizations that your National Endowment for Fact-Checking would be helping to finance, so that they don't have to, I take it the idea is they don't have to spend time fundraising, they spend a lot of time fact-checking.
Right. So there's a group out there called the International Fact-Checking Network. And that International Fact-Checking Network has actually promulgated agreed standards about what's the right way to go about doing fact-checking. So I would look to members of that network in the United States, and that includes organizations like factcheck.org, PolitiFact. There's some other ones, I can't name them all off the top of my head, although for audience members who are interested, you can look up the International Fact-Checking Network and see who the members are. And in fact, the statute includes a provision that says any grantees of federal funding must basically conform with the standards laid down by this International Fact-Checking Network. So organizations who want to get funds would probably want to join that network so that, and get certified by them so that they're eligible for funding.
All right. Since you did mention or suggest people look something up, I will take the opportunity to remind our viewers that we do follow up these forums with an email with some of the links and places to follow up on what we're talking about during the program. So I will get the link for the International Fact-Checking Network from David and send that on to all of you over the next several days, and lots of other links. It's one of the things I think is one of the more beneficial aspects of doing this program is that it doesn't just end tonight. We'll get you some more information and you can follow up. So how exactly, I'm not sure how to put this, but give me an example. We've got somebody putting out something on Facebook. They've got, 500,000 followers. does somebody have to bring this to the National Endowment for Fact Checking or to the fact checking organizations, or it's just part of what they do? I'm trying to get the
Somebody
nitty-gritty nuts and bolts.
Could bring it to them, but the way it's designed under the statute is you start off by identifying who are all these persons with large electronic megaphones, who are the people that meet the statutory threshold, whatever the threshold is, by virtue of the size of their audience. And then you would set up regular monitoring of those people. And you only monitor public communications. You don't monitor private communications. So I don't think this proposal raises any significant privacy concerns. And some of the details here would be left to work out after implementation. For example, the National Endowment for Fact Checking, which is distributing money to different organizations, might say, we'll give money to this organization to monitor Facebook, and we'll give this money to this organization to monitor radio. Or they might say, no, we want to have this group monitoring elections and this group monitoring public health related information, right? So I'm not sure how they would divide it up, but presumably they try and come up with a division of labor and say, we're giving money to this organization to pay attention to this, whatever this is, right? And then they would be proactively, then the fact-checking organization, say it's PolitiFact, right, would be proactively monitoring whatever they are sort of responsible for monitoring under the agreement that they've got with the endowment, which is handing out the money.
So, and the threshold to define a large megaphone speaker, is that in your legislation, or is that something the National Endowment would define once they're up and running?
So I've put numbers into the draft legislation in brackets, but I think this is something Congress would really have to look at and, make a decision about what's the right way to draw that number. Right? What's the right threshold to set? Because if you set the threshold too high, you end up not paying attention to a lot of people who could be very influential, right? But if you set the threshold too low, it may become administratively unmanageable. And I personally don't think I have enough factual knowledge to be able to say what's the sweet spot here, right? But Congress could certainly call in, hold hearings, call in experts, get people with, more knowledge than I do of these different media environments, and on that basis, sort of decide, here's the right number. Now, I also leave it under the statute. I would give the Federal Communications Commission authority to modify that number over time, to enact new regulations to sort of change the number, because I don't think you want Congress to set it once and it's forever fixed.
Right.
But I think you do need Congress initially to sort of set the number and then give the FCC authority to tinker with that number over time.
Okay. I'm relatively sure, though, that my 38 followers on Twitter are not going to get me on this list, though.
Yeah,
All right,
you and I are in the same boat there.
Let's bring our audience into this, folks. If you're watching at home and you have a question or comment, this is a conversation. You probably know by now how to raise your hand on Zoom, but click the little raise hand thing, and we will bring you on camera. So watch your chat for some instructions from our director, Stan, who will tell you you're coming up next. When you are brought on as a panelist, you'll actually see your screen disappear a little bit. When you come back on, you'll be a panelist. You need to start up your video yourself. We cannot start your video for you. Only the National Security Agency has that power in this country. So I see some hands coming on, and we will get Stan on there. Let's talk about kind of reaction that you've gotten to this from colleagues in the legal field to, I assume you've already talked to some folks on Capitol Hill about it. What kind of reaction are you getting?
Well, let me start with law professor comment. So I will say that my earlier draft of the statute was more aggressive in, I wanted the government to have some ability to impose sanctions on individuals who were repeat offenders. And I personally think that's defensible under the First Amendment, but it's really pushing the envelope. And so several of my law professor colleagues persuaded me that's probably not a good way to go. It's sort of too dicey under the First Amendment. And so I sort of walked that back and got this system, which is really relying more on reporting, but no actual government sanctions. So I have talked to a number of folks on Capitol Hill. I think I've gotten some very enthusiastic reception from various people. My goal is to find a couple of senators and congressmen or congresswomen who will actually sponsor legislation or sponsor a bill based on my proposal. I'm not there yet, but I think I have a decent chance of getting there.
Okay, and I meant to mention when we invited the audience to come in, I understand that you've let a lot of Santa Clara students know about this, and presumably we have some Santa Clara students tuned in. Please don't hesitate, even if you're a first-time attendee here, students, to get your hand up and join us. I'd love to hear how the internet generation is thinking about this. And let's go to our first audience member, Michael Abramson. Michael, welcome, and what's your question?
Yeah, so my question is that if you focus only on these big megaphones, is it possible that those who interject this fake news, misinformation, disinformation, they will do it in very distributed fashion, so it will never go through this big megaphones, but spread like a fire through this interconnected network of small users that would not be detected this way?
Well, I think what the empirical research suggests is that if you want it to spread to a lot of people, you ultimately need the help of these people with large electronic megaphones, people with very large audiences, to spread it to a lot of people. So, for example, right, at one point when there was a lot of controversy over a lot of people on the political right thought that Facebook was censoring voices on the right. There was a movement to Palo, right? And you got a lot of pretty toxic content spreading around on Palo. But that was pretty self-contained. It wasn't reaching really big audiences because it was sort of inside a closed group. So my proposal, if it was actually enacted and this legislation became law, it wouldn't prevent that from happening, right? You could get, and this may not be a tiny closed group. It might be a closed group with 10,000 people or something like that, right? But it would be contained in those kinds of channels, because I think in order to really reach millions of people, you need the amplification, if you will, provided by these big name people with large audiences.
Okay, well, thank you for the question, Michael. We also have a question in the chat, and I'll read this, and while Stan gets our next questioner on screen. Sharon writes, I hate to say it, but this sounds like a fool's errand. I don't think you can find any person or group of people whose fact-checking skill nor their objectivity would satisfy everybody or even most. Perhaps something more like the old equal time rule would work better. I suppose you might agree with that, but I take it we can't get the equal time rule back.
Well, I'm not sure that the equal time rule would work better, but let me say, the goal here is not to come up with a neutral, it's not a single, but a group of neutral fact-checking organizations that everybody accepts as objective and valid, right? I just don't think that's possible in our current polarized environment. But if you have fact-checking being done by neutral fact-checking organizations, and 80% of the people out there accept that, yes, what they're doing really is politically neutral and objective and valid, that would be a good thing, right? If you can, and particularly if their decisions basically are effective in putting pressure on companies to de-amplify these individuals because the companies are worried about potential reputational harm or something like that, right? But I certainly agree that no matter who's doing the fact checking, there's going to be a minority of people out there who say, "Oh, we can't trust them; they're biased, etc." Right? And the question becomes, how big or small a minority is that, right? And I would hope it would be a relatively small minority, and if that's true, then I think this would work reasonably well.
Okay, I'm told by our director that Jonelle Prizer, we're having trouble getting your video on, but we will try to get your audio through for your question. So
I don't have one. Oh dear.
Oh, okay. Okay. So yes, we can hear you. And welcome, Jonelle. What's your question?
I don't have a question. I'm sorry, Paul. I'm screwing up on my computer.
Oh, I see. Okay. Well, nice to hear from you, and thanks for joining us. Okay. I don't see any other questions in the queue right now. I would really like to encourage people to come on with your own ideas. If
Paul, I'm seeing something in the Q&A. Do you want to look under the Q&A?
oh, okay. Yeah, well, that one is the one I just asked you.
Okay. Well, then I'm seeing something else in the chat. Never mind. Okay.
Okay.
Yes, I think that's it.
It's not questions. It's just, yeah, it's messages from Stan.
Right.
Okay. Well,
Well, we do have someone else who's raised a hand now.
yes.
Ron's on his way.
Ron Zucker. Okay. Ron is on his way. So we will wait for him to get here. Ron, don't forget to turn your video back on.
I believe I'm on.
Welcome.
Okay. I guess I
Right.
wanted to drill down a little further into talking to legislators who might be interested in introducing something like this. Have you got any specific people in mind who could possibly maybe carry the ball for you a little bit in Congress?
I suppose you're really looking at which committee would need to deal with this at this point, right?
So let me tell you. So I do. There are a number of individual offices of both senators and representatives who I've been in touch with. I'm reluctant to name names at this point because I don't have anybody who has said, yes, I'm going to sort of sponsor this legislation. I will say a little bit about sort of how I went about that. So not being a sort of a real Capitol Hill veteran, I, several weeks ago when I was sort of starting this, talked to an old friend of mine who has actually spent a lot of time lobbying Congress. And her advice to me was, look for all of the bills that are sort of similar to what you're proposing. Look for the people who have sponsored or co-sponsored those bills, and then reach out to those offices, because that's where you're most likely to sort of make headway in finding someone who would actually sponsor this legislation. So that's the approach I took. And then the other thing that Paul was just raising is you got to worry about what committee in Congress has jurisdiction. So I do not claim to be an expert on sort of jurisdiction of different committees in Congress, and it's still a bit of a mystery to me, but it seems like the main committee on the House side is going to be the Energy and Commerce Committee. So I've been trying to find people on the House side who are on the Energy and Commerce Committee who might be sympathetic to the legislation. And on the Senate side, it's I think it's called Commerce, Science, and Technology or something like that. And again, there are specific subcommittees of both of these that deal with telecommunications. And so, you know, people who are on those subcommittees dealing with telecommunications are likely to have familiarity with the issues. And at least some of them, I think, are sympathetic to what I'm trying to do here.
Before you leave, Ron, oh, well, Ron has left. I was going to mention, I was going to mention that Ron is with Peace Action of San Mateo County, and they meet on a regular basis with Congresswoman Jackie Spear up there.
Right.
Is it too early for them to be not bringing up maybe this idea specifically, but to talk to her about this concern, or maybe say, hey, we just came across this proposal. Why don't you look at it and let us know what you think next time we meet with you? Is that kind of activism helpful at this point?
I think it's always helpful for people to talk to their sort of individual representatives and say, look, I'm really worried about the problem of disinformation. What are you guys doing about this? You know, and you know, I will say I have not been in touch with Jackie Spear's office, but you know, if you wanted to say, hey, I understand there's this proposal floating around out there that looks interesting, you know, that would certainly be helpful. I have set up a website for my legislative initiative, and that's something that after, when Paul is sending around links to stuff afterwards, I'll have him send around a link to that website and people can take a look at the website. I am in the process of modifying the website, but that's okay. I think the gist is there.
Ron, if I could ask you a question, and don't forget to unmute yourself. Is this something that you have already brought up with Jackie, or is it not this particular legislation, but the question of disinformation, which has had such an impact as we started out this program, going back to the 2016 presidential election and right up through the horrors of January 6th. Is this something that you've talked to her about at all?
Not really. The last meeting we had with her, which was around August or so, we talked more about really foreign policy and peace related issues, military budget, and rejoining the Iran nuclear deal. And such things as that, you know, ending endless wars. Your
standard issue areas,
right,
yeah,
right.
Sure. But this kind of flows over into all issues, because
take your point, yeah.
If we don't have good information, we can't have good debates in this country about whatever the issue is. So, and do you think this is something you would bring up with her?
I think it's possible. I don't think we'd make a whole big presentation, but I think it would be something that somebody could talk about. We sometimes, you know, get out of our lane, and you know, even with meetings with her. So I could see that happening. Usually when I'm doing action alerts and, you know, emails by email or in our newsletter or whatever, which it has to do with something, we sometimes can talk about other things. It usually has to do with more specific legislation. And so that's why I'm hoping that, you know, rather than saying, you know, this is an issue we're concerned about, and tell your Congress people, you know, Speaker or issue, whoever, you know, to do something about this or support any legislation that comes along, or draft legislation, introduce legislation.
Yeah.
So it's a little tricky, you know, with that we could go on and on about all the different issues, you know.
Sure. But you'd rather go in and say, here's HR 255, written by Professor David Sloss, and we'd like you to co-sponsor it, something like that.
That's where we lean. That's where I lean to doing.
Yeah. Okay.
So if something like that comes along, but I take your suggestion, you know, for future meetings about maybe somebody can make a presentation to her, or you know, raise the points of misinformation and disinformation.
Okay, well, thank you. And thanks to all the great work that Peace Action of San Mateo County does. Keep on going.
Thank you. And
Okay,
the
we've got
encouragement.
another question here in the chat, and it's a good one because I've been thinking about this a lot myself recently. J Rock notes, this program is on Facebook, despite Facebook being severely shamed recently. How does that bode for the effectiveness of shaming? I think a lot of us, especially activist groups, are really thinking hard about, we use Facebook a lot. It's a great megaphone for us, if I can use that term.
Right.
And Zoom ties right into Facebook, so we stream these webinars live to Facebook. Are we being hypocritical?
I don't think so. I mean, I take the point. I think it's a good question. And I mean, what it reminds me of is if you turn the clock back a little over 10 years, right? When we got the Arab Spring in 2011, there was widespread optimism that social media was going to be this great new tool for, political organizing. And, now like activists around the world can use Twitter and Facebook to basically organize political resistance and overthrow dictators, right? And there was a brief period of time there where that sort of rosy, optimistic scenario looked pretty good. And then it didn't quite work out that way. But it remains true that that social media is good for all kinds of things, including political organizing, right? And the challenge is to be able to, you're never going to get rid of the misinformation altogether, right? I think that's a hopeless task. But if you can reduce electronic amplification of misinformation, then the good information will sort of bubble up as the bad information is being tamped down. And so I don't think we want to get rid of Facebook or stop doing organizing on Facebook. I think we just want to make it work better so that we get more of the benefits and less of the costs.
Okay, it looks like we have one more questioner here, Veronica. If you could bring Veronica on for us, Stan, and I think that will have to be the last question. We are getting near the end of our hour, and Veronica has disappeared from my list, so she must be on her way as a panelist. Where do you go from here, David?
Well, I'm seeing Veronica. Can you turn on your camera and unmute yourself?
Oh, I'm not even seeing her thumbnail yet.
Oh, okay. I'm seeing that she's there's a box popping up with her name, but that's all I'm getting. So I'm not sure if she heard that.
Oh, here we go. Maybe no camera. You still are muted, Veronica. Okay, seems to be with us.
All right, there. You hear me?
There you are.
Okay. Yeah, so what I'm concerned about is, for instance, there are two main new paradigms in social and economic, or in scientific and economic area that I believe in. I believe in the electric universe as opposed to the Newtonian gravitational. And there are, I won't go into very many details, but there are significant impacts in our day-to-day life about this astrophysical astrophysics thing. I also believe in modern money theory, and Paul, you know this. I've spoken about it at a couple other programs you've done, as opposed to the current economic paradigm that the American public is being told about. My concern is that new paradigms of thought will get a fair hearing in the public arena. And how does your legislation guarantee this fairness?
Yeah, that's a great question. So
it's a good question. Untested theories, are they disinformation?
Right. So this is a really important function of the First Amendment, is to make sure that minority and dissenting views are heard, right? We don't want to stamp out those minority and dissenting views, because what's a minority or dissenting view today could become the accepted wisdom 10 years later or 20 years later or something like that, right? So a couple of thoughts about that. One is that under my proposed legislation, the fact checkers would be focusing only on two kinds of claims. And these are election-related claims and public health-related claims. And I focus on those two because I think they're the ones that are where misinformation is causing the greatest harm to democracy these days. But that does limit, so for example, new scientific theories wouldn't be covered under that. So there's plenty of opportunity for people to put out their ideas about new scientific theories, because that's not going to be covered under either election-related claims or public health-related claims. Same idea with new economic theories, right? So I'm a big believer in that the First Amendment is performing a very important function in allowing new ideas and new theories to sort of percolate up without being suppressed. And I think that the way that I've drafted the statute, it doesn't pose much of a risk in that regard, because I've defined election-related claims and public health-related claims relatively narrowly. And that's really the only kinds of claims that the fact checkers would be focusing on.
I think that's an important distinction to make there. And obviously that comes from our direct recent experience with all the disinformation during both election cycles, 2016 and 2020, and especially the follow-up to the 2020 election. But tragically, all the misinformation that's floating around about the pandemic and the vaccines and things like that. So thank you, Veronica. Good question.
Thank
Good
you.
question to end on. David, any closing thoughts here with us?
No, I'll just say thank you to you, Paul, and to the audience. You've been a good audience. And, I would, encourage everybody to, if it's not this issue, get out in there and, talk to your legislators about issues that you care about, because that's really what makes our democracy function in a healthy way, is if we all get engaged and put pressure on our governments to do the right thing.
Well, thank you, because that's what Peninsula Peace and Justice Center is here for. So Professor David Sloss of Santa Clara University, thank you for taking the time. It's been great to see you again. Let's not make it 2 years until your next appearance, maybe when the book comes out. When is your book due out?
I believe it should be out in April, but I don't have a firm date yet.
Okay, let me know when it's out. And as I tell all our guests here, the biggest drawback to doing Zoom and not being down at the TV studio is I can't walk you out to the parking lot and wish you good night. So I'll just say good night now, because we're all going to just disappear. So,
all right. Thanks very much.
Thank you again, David. Thanks to everyone who tuned in and listened. Watch for an email with more information. And we're always open to your suggestions for topics here on Other Voices. I'm Paul George. Thanks for tuning in. Good night.